This conference will now be recorded.
Good afternoon. This is good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our February 18th, 2021 public meeting. This meeting is being held via teleconference pursuant to Governor Cuomo's Executive Order 202.1 due to the coronavirus emergency. I first want to apologize to everyone for the late start of this meeting, and because of some technical issues, there was a capacity issue with another link that we had, so we have created another one, and so your patience much appreciated, and so I thank everyone for joining. And the Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and loft board rules. First, turn our attention to a vote on the minutes from the December 10th public meeting. Are there any corrections or comments on the minutes?
Believe it or not, these minutes are perfect in my view.
Thank you, Mr. Delaney. We needed that.
Ronaldo,
yes.
Ronaldo, I don't have a comment on the minutes, but I was just wondering, since you just started recording, if we should take official attendance again, even though we've done it. But
okay, sure.
to make sure we have a quorum.
Okay, for the record, Mr. Roche?
Present.
Ms. Roslin?
Present.
Ms. Rajan?
Present.
Mr. Hernandez?
Present.
Mr. Delaney?
Present.
Ms. Torres?
Present.
Mr. Hilton?
Present.
Mr. Barwitz?
Present.
Great.
Oh,
And yours truly. We have a full attendance of 9 members present. Thank you, Ms. Torres. So we any comments? Let's continue on where we are. Any comments on minutes? No comments, Ms. Rivera. Could you please poll the board members?
Motion first. I haven't received motion.
I'm sorry, a motion. A motion to accept the minutes. I'm sorry.
I move.
Second.
Who's speaking?
Who's second?
Hilton.
Mr. Hilton, second. Ms. Rivera, could you please poll the board members?
Who was the first? I'm sorry. I'm not.
Mr. Delaney, and then Mr. Hilton second.
Okay, thank you. Mr. Barber.
Present. Yes.
Mr. Roach.
Yes.
Yes.
Mr. Hernandez.
Yes.
Mr. Hilton.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
yes.
Ms. Roslin.
Yes.
Ms. Rajan. Yes. Chairperson Hilton.
Yes,
9 in favor.
thank you. Thank you, Ms. Rivera. So the next item on the agenda is the Executive Director's Report. Is Ms. Lynn doing this, or Ms. Lynn doing this, or Ms. Lee? Who is available?
Hi, Chairperson Hilton. This is Stefan Clark. If Acting Executive Director Lynn is not on the line, I can go ahead and do that for her.
Sure.
Okay. So first, the governor's order on January 27th, the governor issued Executive Order 202-92, which suspended the in-person meeting requirements of the Open Meetings Law to February 26, 2021. Revenue. The unofficial Loft Board revenue for January 2021 was $12,900. Enforcement, we issued 2 violations in January 2021. On January 21st, 2021, 1 violation was issued at 517-525 West 45th Street for inadequate heat in Unit 2A. On January 27th, 2021, 1 violation was issued at 117 West 26th Street, New York, 10001 for inadequate heat. These issues have not been resolved yet. In addition, at the last board meeting, there was a report that 1 violation was issued at 144 Spencer Street, Unit 610, Brooklyn, New York, 11205 for inadequate heat. That was re-inspected last week, and the issue has yet to be resolved. Litigation, we have 1 new case, 475 Owner LLC versus New York City Loft Board, index number 151133/2021. This is an Article 78 challenging matter of David Coventry, Loft Board Order number 4943, dated February 20th, 2021. In this order, the Loft Board found that Unit 1109 at 475 Kent Avenue, Brooklyn, New York, should have been covered under the loft law, and its occupant granted protected occupancy status. The Loft Board found that the unit's exterior terrace balcony space should be considered in determining whether the unit met the requirement under MDL 2815 that the IMD unit must be at least 400 square feet in area. The owner of the building now challenges that determination. And that is the end of the executive report.
Thank you, Mr. Clark. Is there any questions for Mr. Clark?
Doesn't seem to be working. I think this plug is no good. I think
Mr.
this
Boris,
is-
Mr. Boris, you're live. Is there any questions for Mr. Clark? Thank you, Mr. Clark. I appreciate you picking up the slack on that. So now we turn to a vote of the cases. First, we turn to the appeals and reconsideration calendar. There are 3 cases on the appeals and reconsideration calendar. And the first case is, I'm going to say it the way I know how to say it, is Kai Plaza LLC at 79 Kai Street, Brooklyn, New York, AD 0106. Ms. Lynn, who is presenting for Ms. Lynn?
It'll be me, Chairperson Hilton.
Thank you. Ms. Lee will present this case.
Thank you, Chairperson Hilton. Case number 1 is an administrative appeal filed by the owner of 79 Key Street, Brooklyn, New York, which challenges the administrative determination dated May 28, 2020, made by the former executive director. The former executive director determined that the owner's application for removal from the Loft Board should be held in abeyance pending the completion of a sale of rights for the building's sole protected occupant. Owner appealed this determination, arguing that the multiple dwelling law does not require that the sale of rights be completed prior to removal, and that the Loft Board staff has sufficient information to set the legal regulated rent for the unit. This proposed order agrees with the owner. An incomplete sale of rights is not a basis for denying the process of a removal application. The Loft Board staff is directed to proceed with processing the removal application.
Thank you, Ms. Lee. Are there any, do we have a motion to accept this case?
I'll make a motion.
That's Ms. Roslin. Do we have a
Yes.
second?
Second, Hilton.
Mr. Hilton seconded. Thank you. Any comments on this case?
This is Julie Torres. I had one comment.
Sure.
I was wondering, the case took place a couple years ago. Is there any further information on the second portion of the tenants? The tenant and the landlord were agreeing to a buyout, I think. But half the payment wasn't made yet, and that was a couple years ago. Has it been made since? Or is that information that we don't know?
Ms. Torres Moskowitz, we will have to get back to you on that question.
Okay. Okay. Thank you.
The date was December, yeah? So it should have passed. I mean, if they did conclude their business, it would be done with.
Okay, any other comments? Absent comments. So, Ms. Rivera, could you please poll the board members?
Did you call my name?
Yes.
Whose name?
Yes.
We're polling the board members.
Yes. Okay.
Ms. Rivera, are you, Mr. Rivera,
Yes.
we're having a volume issue with you, maybe? Could you start over polling the board members?
Sure. Mr. Roberts,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney, Mr.
Sorry, yeah.
Delaney,
Delaney?
Yes.
Okay, Mr. Delaney has indicated yes.
Ms. Torres,
Yes.
Ms. Rosen,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes,
9 in favor.
thank you. The second case on the appeal and reconsideration calendar is 470 Manhattan Avenue LLC. The address is 18 through 22 Eckford Street in Brooklyn, New York, and that docket number is AD 0107.
Thank you, Chairperson Hilton. This case involves an administrative appeal application that was filed by the owner of the building located at 18 to 20 Eckford Street in Brooklyn, New York. The owner challenges an administrative determination that was made by the former executive director on June 25, 2020. In the administrative determination, the former executive director lifted a suspension on the answer period for Loft Board docket number LN0028. The subject of which is a D coverage application that was filed by the owner. The former executive director directed the residential tenants of the building to submit their answers in response to the owner's D coverage application within 35 calendar days from the mailing date of the administrative determination. The owner makes several arguments on appeal. However, this proposed order finds that there is insufficient evidence to establish that the owner has been aggrieved by the administrative determination. The owner has not persuasively demonstrated that the administrative determination has caused or will cause the owner to suffer any actual injury. In fact, by lifting the suspension on the residential tenant's time to answer the owner's decoverage application, the administrative determination provides a remedy which the owner has been seeking from the Loft Board. Accordingly, this proposed order finds that the owner's appeal is procedurally deficient and that a denial of the owner's application is appropriate.
Thank you, Ms. Lee. Do I have a motion to accept this case? And I can't see everyone, so you just no raising of hands, you just have to say it out loud in your name, please.
Yes. Elliot, I move.
Mr. Borowitz is moved. Who seconded?
Robinson Hernandez.
Mr. Hernandez is second. Thank you. Do we have any comments on this case? Absent any comment, Ms. Rivera, please poll the board members.
Mr. Roberts,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Torres,
Yes.
Ms. Roseman,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
9 in
Thank you, Ms.
favor.
Rivera. I'm sorry, what was that count, Ms. Rivera?
9 in favor.
Thank you. The last case on the appeal and reconsideration calendar is Workable 239 LLC. The address is 239 Banker Street in Brooklyn, New York. That docket number is AD 08, and Ms. Lee will again present this case.
Thank you, Chairperson Hilton. This case involves an administrative appeal application that was filed by the owner of the building located at 239 Banker Street in Brooklyn, New York. The owner challenges an administrative determination that was made by the former executive director on April 13, 2020. In the administrative determination, the former executive director denied the owner's application for an extension of the code compliance deadlines set forth in MDL Section 284 and the Loft Board's rules. According to the Loft Law and the Loft Board's rules, the executive director may only grant an extension of code compliance deadlines where an owner has demonstrated that it has met the statutory standards for an extension. An owner must demonstrate first that the necessity for the extension arises from conditions or circumstances beyond the owner's control, and second, that the owner has made good faith efforts to meet code compliance deadlines. In the administrative determination, the former executive director found that the owner here had satisfied the first statutory standard, but had failed to satisfy the second statutory standard, that is, the good faith efforts standard. In order to satisfy the good faith efforts standard, the Loft Board has held that an owner is required to demonstrate good faith effort, not merely good faith intentions. This means that an owner must show with corroborating evidence concrete acts that it has taken toward legalization. Here, in the underlying extension application, the owner had failed to provide adequate details and corroborating evidence to support its claim that it had made good faith efforts toward legalization. The additional facts and information which the owner offers on appeal to bolster the facts that were presented in the underlying extension application are derived from new evidence which the Loft Board is prohibited from considering on appeal. Pursuant to 29 RCNY Section 1-07.11d, the Loft Board may not consider any evidence not presented to the Loft Board staff unless good cause is shown as to why the evidence was not previously available. Here, although the owner explains the reason as to why it offers additional documents on appeal, it fails to sufficiently demonstrate good cause as to why the additional documents were not previously submitted with its extension application. Furthermore, the owner claims, among other things, that the former executive director misapplied governing law by holding the owner to a higher burden of proof than is usually applied to new owners. Specifically, the owner argues that the 2006 amendments 29 RCNY Section 2-01B, which granted more time for new owners to file an extension application, were intended to treat new owners differently from existing owners. The owner asserts that the type of proof required to demonstrate a new owner's good faith efforts is significantly less rigorous than that of an existing owner. This proposed order disagrees. According to the 2006 amendments, the Loft Board clearly intended the standard of proof that is applied to new owners to be the same standard as that applied to all owners seeking an extension. Although the 2006 amendments modified 29 RCNY Section 2-01B1, allowing an additional 90 days for new owners to apply for an extension of code compliance deadlines, they did not alter the good faith effort standard 29 RCNY Section 2-01B2. Moreover, this proposed order finds that the former executive director did not err in her reliance on matter of DeBar Realty Corporation, Loft Board Order number 2234, and matter of 145 Reed LLC, Loft Board Order number 2839. Insofar as the owner alleges that the former executive director failed to credit the owner for actions that were found to be sufficient in other cases, this proposed order finds that this argument is also unavailing. The owner specifically cites matter of 140 Metropolitan Avenue owner LLC, Loft Board docket number EX0107, which this proposed order finds to be distinguishable because in that case, the owner was further along in the legalization process than the owner was here in the instant case. In sum, this proposed order finds that the former executive director did not err in denying the owner's extension application and correctly applied the law. Accordingly, this proposed order finds that a denial of the owner's application is appropriate.
Thank you again, Ms. Lee. Do you have a motion?
I move.
Mr. Delaney. Second.
Second.
Mr. Rajan. Mr. Rajan has seconded. Thank you. Do we have any comments on this case?
I would just comment that this is exactly the kind of case that is part of the reason we have so many visitors here today, guests, because there is a widespread concern in the tenant community about landlords getting extensions under various circumstances. This is not, this particular case is not one where the owner has a pre-established track record of being a bad actor. We'll talk about that a little later, but I commend the board for researching this case as carefully as they have, laying it out, and coming to the proper conclusion.
I would comment that while the
Just
applicant may have,
for the record, Mr. Hilton is speaking.
thank you, Ronaldo, Mr. Chairperson. I would comment that while the applicant in this case has been seen not to make the good faith effort, I think there are facts within the information that the subsequently provided that I understand we cannot by rule include or use in consideration, but I think this actually makes the argument for where a applicant has actually put forward a good faith effort, maybe has not demonstrated within the application initially, and now is trying to correct. So the full information provided. This actually is more of an argument as to why there is a need to look, not have a hard rule of one extension only.
Thank you, Mr. Hilton. Any other comments? Ms. Rivera, could you please poll the board members?
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton.
Abstain.
Can you repeat?
He's abstained.
Abstain.
Okay. Mr. Delaney,
Yes.
Ms. Torres,
Yes.
Ms. Rosen,
No.
Ms. Rajan,
Yes.
Chairperson Hilton.
Yes.
7 in favor, 1 abstain, 1 against.
Thank you. The motion carries. Thank you, Ms. Rivera. There are 3 cases on the summary calendar. They are voted on as a group. The cases are American Package Company, Inc. at 226 through 240 Franklin Street in Brooklyn. That docket number is LS0262. Then we have Nicholas Spector, and that address is 250 Moore Street in Brooklyn, New York. Docket numbers PO 10136 and TA 0272. Then we have Keith Kalowski at 193 through 199 Knoll Street in Brooklyn, New York. Docket number TR 1379 and TR 1380. Is there a motion to accept these cases?
Yes. Robinson.
Mr. Hernandez is voted to accept the case. Any second?
I can second.
Mr. John, thank you. Ms. Rivera, are there comments? I'm sorry, are there comments on these cases? No one wants to comment, so therefore, Ms. Rivera, could you please poll the board members?
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Torres,
Yes.
Ms. Rosen,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton.
Yes.
9 in favor,
What was that?
9 in favor.
Thank you. Thank you, Ms. Rivera. Without objection, the last case on the calendar I would like to table until next month. That case is 54 West 22nd Street, owner LLC at 54 West 22 Street in New York, and docket number is LE0715. The chair is tabling this case until next month. Any objections? Thank you. That ends our cases. The next item on the agenda is rulemaking and updates, and Mr. Clark is going to lead that discussion. Just
Mr.
for
Chairman.
everyone. Yes, Mr. Delane.
Before we start, I would like to make a request of the chair and Mr. Clark. It's my understanding from prior email correspondence with Acting Executive Director Lynn that the working plan for today was to resume the rather dry discussion of the comparison between the oath procedural rules and the Loft Board procedural rules. And while I agree that that's important, I'm of the impression that the large number of guests that we have today are here because they have a concern about the board's discussion about the extension provisions in 201B, I believe it is. And since it's already almost 4 o'clock, I wonder if we could start with that discussion rather than take up the procedural issue.
You actually first me on that, Mr. Delaney. Yes. So, Mr. Clark, that would be my direction. Let's do that. And I just wanted to say I do intend to take this meeting up until 5, if board members are available. Mr.
Yes,
Clark,
Chairperson, I can hear you. Yes, can everybody hear me?
Yes.
Okay, great. We'll go ahead and we'll table the comparison for oath, the procedural rules between oath and the Loft Board rules, and we'll take up the discussion with the extension rule discussions. So, board members, the document that we're going to be working off of to facilitate this discussion, it's the chart that at the top of the page, it says notes, current rule, proposed rule, and the NYCLT suggestion. So with this document and the discussion, so for the owners, the new owners representative that we have, Mr. Hilton, I would just like to say that the board members have previously discussed this extension rule, and we've come up with a proposed rule for the extension rule. We are revisiting that now because we do have a new owner's rep that we want to weigh in on the proposed rule. And also we have suggestions for the extension rule from the NYCLT. It's a tenant association that has made suggestions on the proposed extension rule that we currently have. So the way that we'll discuss this for the next hour is the board members have already drafted a proposed rule. So what the board members would need to take into consideration is the suggestions from the tenant association. If they would like to comment on that, if they would like to include that in the proposed rule that we already have, that's just something for the board members to discuss here. And for Mr. Hilton, who is now the owner's rep, you have an opportunity to look and comment on the proposed rule that the board members discussed and came up with before you officially joined the Loft Board. You can comment not only on the proposed rule that we have, but also on the suggestions from the tenant association as well.
Mr.
And
Clark,
yes,
before we turn to the proposed rule and or the suggestions that were put forth roughly a year ago by New York City Loft tenants, I would just like to remind those board members who were with us then and explain to the board members who have joined since then, Ms. Rajan and Mr. Hilton, that the draft that is currently on the table that provides for an amnesty period where anyone can apply for an extension and also provides for multiple extensions differs from the rule that we currently have and that has been in place for 15 years or so. And earlier today, we had a number of appeal cases of administrative determinations taking issue with the actions of the former executive director. And I have to say that one thing I would be critical of with regard to the former executive director is that there was never really an articulation of the rationale for changing the rule that's currently in effect. And so before we start to discuss the merits of either the current proposal or the NYCLT, call it counter proposal, I think it would be very helpful to have the staff articulate the reasoning behind the current proposal. And the other thing I would just like to point out is that the actual New York City Loft tenant position is what we would really like you to do is do away with this proposed amendment altogether. And that's really the first step that we think should be taken rather than discussing alternative language.
And Mr. Delaney, in that case, I don't want to waste people's time if the rest of the board is wants to chime in on that first piece. We should do that before we even go further, right? That is deciding whether or not you want to change the rule. Otherwise, this, you get my point. I don't want to debate the rule and realize that the board doesn't want to change it. So this is your rule.
I think the threshold step to that is to ask the staff to explain why they were proposing a change in the first place. I mean, for example, if we decided to change the minimum housing maintenance standard heat requirement to a lower heat requirement or even a higher heat requirement, you'd expect that the staff could explain why a change would be a good thing.
Okay. It's that. I'm not sure if a lot of these staff members were around when this proposal came from former executive director. Are you ready for that?
Hi, Chairperson Hilton. I'm not sure if anybody heard that distortion, but can everybody hear me clearly?
Yes.
Okay. I'm sorry you were a little bit distorted, Chairperson Hilton, but I'll try to address Mr. Delaney's.
I'll say it again. Are you prepared? Is the staff prepared to as Mr. Delaney is asking for a rationale behind the rule change? The rule will not change, but the rule suggests the rule change.
I'm sorry, you were still very distorted, Chairperson Hilton. But I'll go.
Am I well? Is anyone else hearing me?
No,
Chuck, can you hear me?
Chairperson,
Ronaldo,
impossible to hear you right now.
there's a suggestion in the chat, Ronaldo, that maybe you should leave the meeting and come back in.
Or call in.
In the meantime, can Mr. Clark proceed at least?
Sure, I think that would be
Mr. Clark,
good.
Mr. Clark, can you proceed at this moment so we can at least have some conversation about this?
Yeah. One thing I want to ask is anyone hearing me at all?
Chairperson Hilton, we can hear you, but you're just greatly distorted.
All right, go ahead. Hold on.
Okay. So I'm going to go ahead and try to answer the question as best I can. I know that we had discussions about this in the past, why the Loft Board even fathomed changing this rule. I would have to go back in the minutes to try to get an exact answer of why the former executive director, what her rationale, what her reasoning was, and also the board members at the time that agreed to coming up with a proposed rule, what the rationale was behind that. But from my recollection, it's basically a balancing of two interests. Obviously, there are some severe ramifications for an owner that falls out of compliance. And there are various reasons why an owner might fall out of compliance. And when we mean compliance, we mean the deadlines that are set for the owner to reach specific milestones. There are specific dates that the owner needs to meet certain milestones. And if the owner does not meet those milestones on that specific date, then we consider that owner to be out of compliance, and there are consequences for owners that are not in compliance. We understand that many of the buildings that come under the Loft Board's jurisdiction, some owners are not familiar with how the Loft Board works and how the loft law works. But there are many instances where buildings come into our jurisdiction and they're already out of compliance. Additionally, there are certain actions that the owner needs to take, specifically with getting that permit. That permit involves sometimes a very long narrative statement process. Sometimes it's a contentious narrative statement process. And it does take a significant amount of time. If it's particularly contentious between tenants and owner, it might get to an alternate plan where OATH has to take it over. There's a full hearing that's presented, and that takes up time for them to make a report and recommendation, make a decision, give a report and recommendation, send it back to the Loft Board. Loft Board staff review it, create a proposed order, send it back to the board members for them to ultimately vote on it. That sometimes takes a tremendous amount of time, and it does impact how quickly an owner can move through the legalization process and hit their milestones and stay in compliance. Now that's really just me working as a staff member and balancing the issue. Sometimes there is an owner that is just not doing what they're supposed to be doing. They're dragging their feet with submitting documentation that they need, sending out narrative statements, things of that nature. There are owners that are not being diligent in moving through the legalization process, but there are other owners that might face situations and circumstances that might prolong the legalization process. So I know that the discussion and the reason for the proposed rule hinged on allowing owners that are really trying to move the legalization process forward. The additional time to try to get things done in good faith before the severe consequences come down on an owner for falling out of compliance. So that is the basic idea of it. Like I said, for the specific reasoning of the previous executive director and what the board members were discussing as the rationale to change the current rule, I can research that and come back with some bullet points next month, but that is the basic idea. It's a balancing between the owners and the tenants that need a safe place to reside, but at the same time, understanding that the process might come, there might be hiccups and bumps along the road that might prolong the process, and it might not be fair to have such a draconian consequence for falling out of compliance when there are some owners that are actually trying their best to legalize the building. So sorry if that was a little long-winded, but we can start the discussion there and find out where the board members are. If there's a change of heart, and board members don't feel we need to make any changes to the current rule, then you know, we're here to listen to the arguments on both sides and try to see if we can come up with some type of middle ground, or if we need to change it at all, or if we do need to change it, are we happy with the change that we already have, or do we want to incorporate other ideas and arguments and take other perspectives into consideration?
Thank you, Mr. Clark. Anyone here any better now?
Oh,
No.
no.
No, you're not any better, Chairperson Hilton.
Mr. Clark, I appreciate your explanation, which I don't find long-winded. There are basically two things that are highly questionable and, frankly, from the tenant point of view, offensive and kind of threatening to a lot of people's health and safety in their unit. One is allowing every owner, the current proposal, allowing every owner a chance to apply for an extension. And the other, which you did not touch on, is the rationale for allowing multiple extensions for a single code compliance deadline. I wonder if you can comment on that.
Sure. So with the proposed rule, as you said, Mr. Delaney, there are, I think, the two major points with this proposed rule is allowing all owners to have an opportunity to file an extension application within 30 days. I'm sorry. I think it's our rule says within 30 days of the effective date of the amendment, all owners can submit an extension application. That is one key point. And the reason and the rationale behind that, I believe, is just to allow owners just one more opportunity to get it right. Whether or not the board feels at this time that that's still a good idea. I know at the time we understood that there were many owners out of compliance that would not otherwise get an opportunity to be in compliance, to have them have an opportunity to get an extension and try to move the legalization process forward at that time. That is one point. I think it was a compromise at the time between the board members to allow that. And the second point, as you said, Mr. Delaney, is to allow multiple extensions. And I believe that also was a compromise because, as the board members know, proving that good faith and the reasonable efforts it's a very hard standard to meet. I could say statistically, most of the extension applications that are submitted to the Loft Board are denied. And it's a process that the Loft Board, after we look at all the information, we look at everything that's presented before us to meet that statutory standard, and we write our proposed orders, and it's a very difficult standard to meet. So that is, I guess, one of the compromises, and also sometimes it just might take more time to move through the legalization process. There's always something, or there can potentially be something that just causes a hiccup that might take more time than anybody could have foreseen. It might be just an example. Maybe all the tenants in the building are on board with a legalization plan, and it might just be one tenant that's holding out, wants to go to oath, wants to drag out the process. It's not that the owner hasn't made changes to their plan and tried to engage in conversations and agreements with the other tenants of the building. It's not like the owner is completely dismissive of the conditions that the tenants are in, but it might just be one tenant that's holding out and delaying the entire process. So I think the compromise was, if for situations like that, if the owner misses the date in which they are supposed to be hitting that milestone for a good reason, it shouldn't be that the owner can't get a little bit more time just to fall into compliance and move the legalization forward. And I think that was the idea when the board members were discussing it at that time, to have multiple extensions. And it's also, the proposed rule also allows not just the executive director the opportunity to issue multiple extensions. It's also the staff members. And then if there's more than 2 extensions, then it would have to come before the board. If it's the same owner and it's the same compliance deadline, then it would come before the board, and the board members would make the decision on whether or not.
Can you
to issue another
confirm?
extension.
Can you confirm that the Loft Board members are actually reading the chat? Because there's hundreds of people in here that this
Yes.
argument and examples just aren't making any sense for.
We see the chat. I see the chat.
What is stopping landlords from actually doing something now? Why do they need an extension? If they have an intention of fixing the conditions in a building, why aren't they doing it?
Sorry. Anyone hear me? I'm having a little trouble, but we cannot. This is not an open meeting for everyone to talk.
Right. So, Chairperson Helton, you're still a little bit distorted, but as I know what you were saying, this portion of the board meeting is not an open meeting for the public to discuss and submit comments. The public will have that opportunity in the future, but this is for the board members. This is the time set aside for the board members, each of the board members, to discuss openly their opinions and their views on this proposed rule. And this is not the time for the public to comment or speak on the issue yet. There will be a time again, but right now, this is just for the board members to express their opinions and their views on the matter.
Stefan, this is Christian Hilton. So I want a little more background in terms of how this rule came up, because it didn't come out of a vacuum. And the discussions that took place previously in terms of developing the proposed amendment. I believe there was contribution from board members, including Mr. Delaney and Ms. Moskowitz Torres and other folks who have been here previously. Am I correct or am I wrong in that?
Yes, I believe I'll allow the board members to chime in. Mr. Hilton.
Oh,
Go ahead, Julie.
Yeah, I'll just say, so I'm Julie Torres Moskowitz. I joined the board May 2018. I'm an architect and a tenant. And I remember, this is my memory, and I want to go back to like what Stefan said, go back to meeting minutes, because I remember that this was already, to me, this was already on the table, and I was trying to dissect it when I joined the board. I didn't understand why there would be, why they would want to all of a sudden like give a carrot to every single landlord who's out of compliance. And I understand like that carrot and the stick idea, and like maybe some of these, you know, as an architect, ideas, safety for these buildings, they take forever to get through the system. If you can like make it go forward faster and in compliance, that theoretically sounds like a good idea. At the same time, you know, concern for just giving a reward to a bad actor is scary and not good. So I remember I feel like I entered it in the middle of the discussion and I was trying to break it down. I remember with the former director, executive director Elaine, I didn't want to offend her, but I kept saying like, it's not you, it's the next executive director. Like, I don't know who the next person is and if they'll just keep offering new extensions, because I don't know who they are. Like, we have to imagine the worst case scenario in politics. And so that's where I stood at it. Kind of today, I'm liking the going back to just the current rule that we had in place before. But so that's where I stand. Thank you.
Thank you, Ms. Moskowitz. Are there any other board members that would like to comment?
I would comment that the history of the Loft Board is such that there are a number of times that things have either been done or proposed without them being discussed at length by the board. And my recollection is that this draft, the proposed language that, frankly, I don't know which is worse when I think about it, whether it's giving multiple extensions or giving a free bite at the apple to every single owner, regardless of their track record. I think they're both bad ideas. And by the way, the legislature continually, in the last two times the loft law was being discussed, rejected extensions in the timetable as was proposed by the owners. Also, in addition to this rule, to my recollection, kind of just popping up from the staff, back in 2014, 2015, the application for coverage was bifurcated from the protected occupant status with no notice to the board, no public hearing, and no rulemaking. So I appreciate your attempt, Mr. Clark, to kind of explain this from your recollection, but I think it's got a ways to go.
I tend to agree with Chuck. Well, I think it was very important for us, particularly with our last executive director, to be as fair as possible to all parties. But I think we ought to go back to the original resolution on this. Let me tell you, it's very hard for me to talk here where I can't quite see myself or some of the other people. I think this is the last comment I'll make today. Sorry.
You know, as the new representative on this and hearing the various points of view, the overarching guidance for me is what moves applications most efficiently through the loft board and towards legalization. And you know, this, I believe, in terms of my understanding of it, came up as an improvement on an existing system that was not showing that level of efficiency in terms of moving applications towards legalization. I think having just one extension is also not the answer to that. So I would look to still have more conversation and discussion around this rule, and see whether it needs tailoring or whether we can grasp in terms of how it could be applied, that and see whether it'll be effective. Because I'm trying to figure out what, you know, the genesis of this and the discussion. I know does not come out of a vacuum, and I don't think and I think was looked to see to remedy a situation in terms of applications and moving buildings toward legalization.
Thank you, Mr. Hilton. And I understand as well that it might seem like owners are getting a free bite at it, another free bite at the apple, but there's a standard that still has to be met. It's not like an owner applies and we just give them that free extension. That's not how it works.
But that's part of the problem, as we saw today. And we have a case almost every meeting or two where if an owner applies for an extension and gets turned down, then they file an appeal to the board. We had one last month that ran 1,000 pages. So that my personal opinion is that allowing every owner to a free lottery ticket with the chance that they might win something, even if they don't have a lot of good grounds, is just going to swamp the board in a way that makes no sense whatsoever. So I think at this point, I'm inclined to suggest that it might make sense, and I'd like to move that the board consider going back to the original rule as it currently exists and reject any modification.
Thank you, Mr. Delaney. Are there any other board members that want to chime in? I think Mr. Barowitz was speaking.
Well, I think we'd like to call that question. Can we call it?
Oh, somebody needs to second it if that's going to happen.
I'll second it.
All right, so Mr. Delaney made the motion and someone seconded.
Yeah, Julie Torres Moskovitz seconded.
I'm going to allow Chairperson Hilton, if he's available, to
Is anyone hearing me at all? I'm having really big issues here. You're hearing me now?
Now you're good.
Excellent. Oh, good.
Yeah, now you're good.
We can hear you.
Oh, excellent. I was on the phone with Tina trying to figure this out, how I'm going to actually take control of the meeting again. But thank you. So what was the motion? Because I was speaking to someone just now just to try and straighten this out.
My motion is to keep the extension rule as it currently is, and to reject the and to take off the take out of the proposed draft rule changes the one-time shot at the moon and the multiple extensions.
In other words, to keep the rule intact or the way it is,
As it currently is on the books today.
Books. So I just want to understand, is there anything else except for those changes that Mr. Delaney is talking about that are good in the proposed rules? Meaning, is there language changes that were there that we need to keep, or is we're just going to go?
He said keep the rule intact.
I'm sorry, sir. I'm on the board. You're not on board, and I'm asking you, please.
Excuse me.
So I'm just asking the board members for clarity of what their motion is, and is it to just completely disregard all changes into this that was being proposed here, or just those things that Mr. Delaney was mentioning before? Because there may be some other stylistic stuff that was in this rule. Stefan, maybe you can clear that up. Is that the motion?
You mean Mr. Delaney's motion? Is there any?
Are there?
Yeah, I mean, I don't want to speak for Mr. Delaney, but I mean, to summarize what he just said, it just seems like he wants to reject the proposed rule, and also the NYCLT suggestions, and just leave the current rule as is on the books.
That's correct. You distributed, or the board staff distributed, a document which is described as current loft board rules for 2-01B, which is the extension piece. And then it also distributed proposed rules that are the staff's recommendation for changing it. My motion is to let the current loft board rules for section 2-01 stand as they are without any changes.
Thank you. Thank you. I just needed clarity on the motion. Thank you very much, Mr. Delaney. And did I hear a second on that motion?
Yes, I seconded it. This is Julie Torres-Musgrove. I second the motion.
So we're recording this motion as keeping the current rule as it stands and rejecting all changes, correct?
Yes, and I would point out to board members that there already are provisions for extensions for new owners, for owners who contested coverage, and the coverage does not, and the coverage decision is not made at oath or by the loft board until after a deadline has expired. Those owners would still be allowed to apply for an extension.
Okay. Are there any other comments on the motion? Ms. Rivera, are you available to poll the board members?
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
No.
Mr. Delaney,
Yes.
Ms. Torres,
Yes.
Ms. Roseland,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 against.
Thank you. Motion carries, meaning that there will be no change to this rule in this round of rule revision, this rule on extensions. Mr. Clark, does that make your life easier?
Yes, it does. Now we can get on to the exciting stuff.
Right. As Mr. Delaney, so he loves this stuff. Go ahead, Mr. Clark.
Okay, so the next portion of the rulemaking that we're going to discuss today, we're picking up with the oath comments to our proposed rules. And we finished we went through most of the comments from oath, but right now, with the chart that you have, the other sheet that we have is a chart that compares oath's procedural rules with the Loft Board's procedural rules. And again, the reason why we're comparing oath's procedural rules with the Loft Board's procedural rules is because in the proposed rules 1-27, it says where oath conducts a hearing and the Loft Board rules conflict with oath's procedural rules, oath's procedural rules or practice will apply unless otherwise provided by law. Where there is no oath rule or practice regarding procedural issues, the Loft Board's rules will apply. So we are discussing this portion because Mr. Delaney wanted to just highlight any differences between oath's procedural rules and the Loft Board's procedural rules to find out if just to encourage discussion and maybe make modifications to the rule if it's needed. If not, then we can just adopt oath's procedural rules where they don't conflict with the Loft Board rules. So we'll pick up the discussion. I won't go through the sections that we went through last month, but we did get to, and this is the sheet that at the top of the sheet, it says oath rule, Loft Board rule, difference, oath language, and Loft Board language. And we did get to section 1-25, which is amendment of pleadings. And we'll pick up from 1-25. And this is the amendments to the pleadings. Oath requires pleadings to be amended 25 days prior to the start of trial, unless there's consent from the parties or if approved by the ALJ. The Loft Board rules allow pleadings to be amended at any time up to and including the first day of the scheduled conference. So there is a bit of a conflict here. Oath requiring that 25 days to amend any pleadings, and the Loft Board saying that you can amend the pleadings at any time. So I don't really handle the amendments when they come in for the applications, but I asked some of the staff members here, when we do get amendments, after we have an application that we send to oath, when we do get an amendment to that application, what typically happens? And I was told that typically once we get that amendment, if it's already at oath, we just send that amendment to oath and we wait for the specific time period for the answer to come in. If we do get an answer to that amendment, we send it over to Oath. If not, then Oath pretty much determines how they're going to proceed with the hearing that's already in place. So I'm not sure in actuality if there will be a conflict. If Oath simply just takes the amendment and makes the determination if they want to amend and include any type of amendments into the hearing that's already in place, or if they are strictly adhering to a 25-day period that they have for their amendments. But this is an issue that might potentially cause a conflict, and I would love to hear, we would like to hear the Loft Board's board members' opinions on whether or not they're fine with Oath's procedures for amendments that come in. If we want to just basically.
Clark, this is Ronaldo. So what do you think is the rationale behind Oath's 25-day requirement prior to the start of the trial? Is it just for time for parties to consider the court?
I think that's what it is. They just need time to consider the amendment and make their decision.
Do you think that's not reasonable?
I don't see a problem with it. Staff members, I discussed it with the other staff members, and we don't see that as being unreasonable. But the Loft Board's rules seem to be a little bit more generous in allowing an amendment to take place at any time. So are there any comments on this procedural aspect? Oath requiring 25 days prior to the start of trial, unless there's consent of the parties or approval.
So I would ask the board members if this is not something that the Loft Board may consider reasonable to adopt in its own like adopt that principle in its own rules. I mean, should we be having our own tribunal at any time? Would it make sense that we have this requirement also in the matter of notice to people?
Is there any reason not to? Can we think of a reason not to?
I can't think of it. I think this is reasonable. It's a reasonable requirement, that you amend your pleadings and give time for other people to consider, including the court, actually. The tribunal.
What I was told on this, and I emailed Ronaldo and Acting Executive Director Lynn prior to doing so, but I took the very helpful 12 pages or however many pages it is that were created by Mr. Clark and Mr. Argo. I deleted the difference column that constituted the comments and analysis from our staff, and Acting Executive Director Lynn agreed that with that column taken out, so that all that was left was the oath rule, the Loft Board rule, numbers, the oath language, the Loft Board current language, and the Loft Board proposed language. And I circulated that to the attorneys who represent tenants. I also sent a copy of that redacted document to Mr. Hilton so that he could see if he could get some feedback from the attorneys that represent owners, because in procedural stuff, I think the most important thing is that it's a level playing field. Everybody knows the rules. And overall, one attorney who got back to me, who insisted to remain anonymous, said, and I quote, "It's heaven being at oath compared to housing court or even civil court." On this particular point, the feedback that I got is that, as it says, the oath limitation is 25 days prior, unless the parties consent or approved by the ALJ. And apparently that leaves a lot of maneuvering room, so that my sense is we're okay with this. Heather, you raise a very interesting question, which will come up again shortly with regard to, well, if there are places where we think the oath procedural rules are good or maybe better than ours, should we incorporate some of their ideas into our rules in case there does come a day that we start doing hearings again?
Yes, thank you, Mr. Delaney, and thank you, Ms. Roslin. Those are good points, and of course, if board members in going through these documents, if there is something that they feel might benefit the Loft Board rules, then definitely take note of it, and the staff will take note of it, and we'll try to work as best we can to prepare something that's satisfactory to the board members.
So if I understand this right, Mr. Clark, we're looking at replacing, and I'm sorry, I don't want to jump to conclusions here. So the consensus of the board here is that this piece is, this piece of language from oath should just be adopted in our rule. Is that where we're at right now, right? Where if there is consensus, should everybody agree? We could just take that language verbatim and put it here in H in our 106H.
Chairman,
I
I think that Heather was saying she wanted to ask the staff, like, do you see conflict? I'd like to hear back from Tina and the staff on
this piece, though. It's before us. I'm talking about the piece before us.
Okay.
Just this piece. I got it, Julie. I'm just saying this particular piece. If we could, if do we want to take this piece and just adopt it into our 106 1.1-06H? That's what's before us right now.
Right. So, do the board members want to take this language from oath and make it part of the proposed rule?
I'm just saying, if the only difference is that oath requires this 25-day prior notice, and we all agreeing that might just be a good idea, with the language where, unless parties agree or and agreed upon by the ALJ, it may be something that's a reasonable accommodation for our rules. Should we be doing this in the future? When I say we, meaning the Loft Board.
I was thinking there might be a little more research or back and forth on that. Speaking from experience with where we, sometimes there's like quick date changes that happen. On my case, I'm not sure that 25 days, like what that will do to the Loft Law Board. I don't know if we're following 25 days instead of allowing for changes faster.
So there are two ways in which, Julie, my reading of this, there are two ways in which that could happen, right? Less than 25 days is as Chuck pointed out, either the parties agree or by leave from the judge, from the ALJ, from the presider. So do you think?
Oh, okay. Yeah, if I'm sorry, I missed the part. If parties agree to something less, then that seems fine. I just noticed in my own experience that is what.
Right, or even the ALJ may just can do that, can override it. So in the loft board, if that becomes part of the loft board rules, then whoever is the presider at the loft board, if we should have our own tribunal, can make that decision also without anyone's consent. So there's flexibility here, as Chuck is saying.
And because of that flexibility, I don't want to completely speak for Mr. Delaney, but it didn't seem like Mr. Delaney took issue with Oath's rule. And if the law board wouldn't have a problem with accepting Oath's procedural rule for the amendment.
That's a correct assessment.
But the issue now is whether or not, I mean, we don't have to you know, we can decide that now, but I don't know if it's a necessity to incorporate that in our proposed rules unless the board members see immediate benefit to doing so at this time.
Actually, you're actually right? Because where there's a conflict, their rules apply, right?
Yes.
So there's no immediacy in incorporating it. However, remember we just had a discussion a moment ago. If we find something that you know in Oath's rules that may benefit our own rule, wouldn't we want to do that? That was the question here. We can leave it alone because it seems like we're not worried about it as it is right now. But if the language benefits, makes our rule better, why not adopt it? That's the question for the board member.
Right, that's correct. Are there any other comments from the board members? Any other discussion on this? If not, then I know we have a little bit of time. Maybe we can table this and try to get.
Do we need to table it, Mr. Clark?
I don't think so. I don't think any of the board members are.
Are we not? It seems to me by silence, if silence is consent, we could probably incorporate this in our own rules and just make it. And we can change this section 106-8H, 106-1-06H to reflect
1-6H.
Right. This is page what? Page 3, 4 of the handout that we have, Heather.
Yeah.
It seems that what I'm saying here, and correct me if I'm wrong, Mr. Clark, but if we can amend, if we can take Oath's language and make it our language in 106H, would that be acceptable right now to the board members? If not, we can move on. We don't have to do anything, as you said. There's not much of a conflict. That's what I'm trying to say.
Right.
But I need the board members to speak up or say something. If you concur and agree
seems totally fine to me.
Right.
Okay. So I'll make note to incorporate Oath's language into our proposed rule.
For the amendment of pleadings.
Yes.
All right. Without objection, anyone? Hate to sound like a judge, but so ordered. All right, thank you.
I'm good with it. I think people's reluctance to speak might be, maybe they're like me. I'm open and I got the document open with the chart. I see like all these little, I see 1-06. I'm not seeing H. I see G, I see, you know, I see,
Oh, but if you look at the handout, are you looking at the handout? I'm not sure.
I'm on the
Handout that
table, the rule comparison, oath and loft
Yes,
board
right.
version.
And on page 4 of it, it's not numbered the pages, but if you go to the 4th page, you have that comparison of 101-06H to 1-25 of the oath rules.
Oh, I found it.
Right.
Everyone else got it? Anyway, from all we're saying, I'm fine with where you're headed, that it makes sense to incorporate it. As long as there's the flexibility that if parties agree
Correct.
something less than
Correct.
25 days.
And or the judge says it.
Yeah.
Agrees. It doesn't,
Yes.
if one party makes a compelling case to the judge and the judge agrees, he can do that. But otherwise, in the normal proceedings, it's done within, according to oath, 25 days prior, and I think that's reasonable even in our rules.
Right. So I think, so procedurally, what we would end up doing is incorporating that language into the proposed rule, which we have as 1-25A. We would just change that language in 1-25A into
The opposite way around?
Sorry?
The opposite way around? You want to change the 1-06H to incorporate the 1-25 language.
Right, exactly. I'm sorry, yes.
Okay, thanks. Right.
Okay. All right. So
Mr. Clark, I'm gonna stop you from going any further unless you think we could do anything in 2 minutes.
I think okay. I wanted to get through the next two are very difficult. I think that would might need a little extra discussion, but there are two that I think we can finish in 8 minutes if we want to use that time. But if not, we can pick it up next month.
Okay, board members?
Yeah,
let's go for it. It's late already. Which ones are you talking?
Okay, so if the board members can go through the document and get to the oath rule 1-46.
Evidence in trial.
Correct.
On page 25.
Yes. So the evidence of trial, basically the oath rules and the loft board rules, they seem to be, they are very similar in that the traditional rules of evidence do not apply at oath. And our rules are basically the same thing, are saying the same thing. So unless the board members have any reason to object to the way that oath has worded this, then I can just note this as a non-issue.
How come
Yeah,
you
they
wanted
seem
to
very
skip all the
similar,
way to
so-
this one?
I'm sorry, Ms. Rajan?
I was just wondering, like, why you wanted to skip all the way to this one and skip all the ones in between? If there was nothing to,
No, the ones in between are probably going to require much more discussion than we have
these are the
time for.
easy ones. Oh, I see.
Yes,
Okay,
the
easy ones.
yeah.
Great. Let's do the easy ones.
Okay, are there any comments to one?
So is really the difference the word technical and the word formal? And that's, do we,
Yeah, that's pretty much it. And they're both basically saying that the the formal or technical rules of evidence do not apply during the oath hearings, meaning that they're more relaxed with the rules of evidence at the oath hearings.
So yeah, so this is one rule it says formal, one rule says technical, and everything else seems to be the same, correct?
Yes.
Everybody agree that formal and technical are the same things?
I agree, that sounds good.
All right, thank you, Mr. Clark. Move on to the next.
Okay. Next one is 1-49 and public access to proceedings. There's really no conflict here that we have seen. It basically said the law board rules are silent regarding public access to the hearings. And oath just has a rule that says, other than a settlement conference, all proceedings are open to the public. So there's really no conflict, but since the law board rules are silent, we would be accepting what the oath rule says here. And that other than settlement conferences, anybody can come to, the public can come to the hearings, which we think is fine.
Yeah, as it was explained to me, if say from the public shows up, the one thing that the oath judges tend to do is make sure that the person not a potential witness who should not be in the room except when they're being called.
Yes, that makes sense.
As would happen with any legal proceeding or trial, yeah?
One would hope, yeah.
Yes. So do any of the board members have any issues with that? If not, then there really is just one more easy one, and then we can pick up the next board meeting with the two issues that might generate more discussion, lengthy discussion. If there are no comments, then I'll just bring your attention to 1-51. Which is just for the transcripts. It's basically both of the language in oaths rules and the law board rules allow for transcripts for public to get a copy of the transcripts. The only difference is the law board rules specifies that in order for the public to get a copy of the transcript, they have to pay a fee. And oath is silent about any type of fee. But both of them are saying the public can have access to the transcripts.
And as this was explained to me, oath does not charge for digital files. So they make a transcript anyway as part of the record. So if one of the parties wants a copy of the transcript, as long as it's digital, there's no charge. Obviously, the law board's rules were written before that was even an option, but I think we should do the same thing.
So Chuck, you're saying the fee likely went to the covering the cost of paper or whatever it would be to physically make a copy of something. The time,
the copy, yeah.
Right, the time and the material required to do that.
Right. Whereas now, if the if the transcription service does it for oath and sends it to them in a digital file, it takes somebody a minute to make a copy and send it to someone requesting.
Do FOIL requests have a fee associated with them? Do other, like, I'm trying to compare it to other informational requests.
25 cents a page. 5 cents, is it 5 cents? Mr. Rivera, how much is it?
25 cents a page, but not digital. We don't charge for any digital.
So we don't charge for digital.
Mm-mm.
So nothing here, right?
Right, so I think that covers it. The very bottom of that page, you'll see oath rules 1-22 through 1-24. And we just put that there for informational purposes. They concern the filing of petitions and answers, but since we handle that portion of the hearing here at the log board, then it's a non-issue for what oath does, because we take care of that before we even send it to oath with the filing of applications. So those rules at the bottom are just for informational purposes only. And I think that's all we have time for. Like I said, there are 2 more issues that will probably garner more discussion at the next meeting. So we can take care of that quickly. Well, not quickly, we'll take care of that. And then once that's done, we'll be completely finished with oath's comments to our proposed rules. And then we can focus the rest of our attention on the law department's comments to our proposed rules. And we're making progress.
Clark, that was great. Thank you. And I wanted to just right now maybe just comment on the fact that we do need to have 2 additional board meetings on just focusing on rules, so we can expedite this process a little bit. And I think Ms. Lynn will do some polling among board members for early March and for April. Please, if you can, we do need quorum to have these meetings. So as much as possible, please respond to her if she as soon as possible, so she can set this up.
I wanted to add one thing if I could, just generally, that it's good to see so many people from the public joining.
Absolutely.
It gives me the idea that, I mean, we haven't really talked about it in a while since the pandemic hit, but this seems, you know, sometimes in the past, the Law board would do, staff would do like a town hall or informational meeting. And I feel like this shows people, the public can find this maybe easier than coming down to a room somewhere near City Hall. So it seems like this could be viable for a future town hall, just for transparency on, you know, when the rules are going to be published or different kinds of issues that affect tenants and landlords.
Sure.
It seems like they found a. So. Thank you.
Julie, I thank you for those comments, and I actually do want to on that, I just want to say to the members of the public, tenants, whoever was joining this this meeting, the prior meeting, and got kicked off or got enfranchised in any way, I apologize. I take full responsibility for we didn't anticipate it and go to meeting this forum, I guess this mechanism. We have to look at something different so that it doesn't happen again. But again, I'm sorry that it kept people waiting for so long, and I'm sorry that it did create all this this anger and so on. But I appreciate everybody sticking with it. I thank the board members for sticking with it and coming and having such good debates. I think this is great. Certainly, the pandemic has given us or opened our eyes to so many different means of communication and transparency. So this is all good, and I just want to thank everybody for their patience with us. Board members, before I give my last comments. Go ahead.
Ronaldo, I'd just like to say that I think any anger that was expressed was not directed at you or the board, but rather reflects lots of tenants who've had a tough time in their buildings and their concern about the extension rule. I don't think it was at you.
Sure. Well, the debate among the tenants, you know, it turned out fine, right? It actually, backdoor it worked. So I thank you, and I got it. I really got it. Any other board members want to say something? I do have a closure.
Good for today.
All right. Okay, so before we close, I have two announcements, actually. Today will be the last board meeting for Mr. Hernandez, Robinson Hernandez, our manufacturing representative. Mr. Hernandez, are you still there?
Yeah, still on.
Yeah,
Yep.
There you go. There you go. Okay, good. Mr. Hernandez joined us back in December of 2016. And at that time he joined, the Loft Board was without a benefit of a manufacturing rep for many years prior. I want to express my thanks on behalf of all our fellow board members, and as well as on behalf of the City of New York, to Mr. Hernandez for his contributions over the years to the operations of the Loft Board. He put his substantial expertise and experience to work as a public servant, and I tell you, Robinson has been a public servant with the city for a very long time. Certainly, we've known each other for 15 plus years. And we owe him a lot of debt of gratitude for his time on the Loft Board. So we wish him best in his future endeavors, and he will have an opportunity to talk about that. But I hope our paths will cross in the future.
Great.
All right.
Thank you. And I'll send the note out to everybody. So thank you so much. Appreciate it. You have a lot of Godspeed.
Well, thank you. We're gonna miss you.
Thank you. Likewise. Likewise. And I'll send the note out to everyone soon. So I can get it. You know, I know we've run over. Sorry.
Thank you, Robbie, and thank you for bringing the debate on extensions to an end. I appreciate it before you left. That was an agreement, right?
Right. Yeah. Right.
Thank you, Mr. Hernandez.
Take credit. Take credit. Okay.
Oh, sure.
So the
Okay.
mayor,
Yeah, you're welcome.
okay. The mayor has decided on a replacement for Mr. Hernandez, and that person is Kai. I'm going to say this. I hope I say it right. K-E-I, and the last name is H-A-Y-A-S-H-I. Hayashi, to succeed Mr. Hernandez, and she will be joining us as a manufacturing representative starting on the March 18th meeting. This may be even earlier if she joins. She may join us before on if we have a rules meeting, and she's able to join. She may come, but officially for now it's the 18th of March.
Ronaldo, can you give us her name again, please?
Yes, K-E-I, Kai. I say Kai. I hope I got it right. I haven't spoken to her. I don't know the pronunciation, but it's K-E-I, and the last name is H-A-Y-A-S-H-I, and I pronounce that Hayashi.
Thank you.
Thank you. So I need to go shovel my snow. This will conclude our February 18th, 2021 Loft Board meeting. Our next public meeting will be held on Thursday. So we don't, I'm saying this because I don't know if we're going to have a rules meeting earlier, but we are going to poll you for a rules meeting. But officially the next board meeting, which will discuss cases, will be March 18th, 2021 at 2 p.m. So the governor's suspension of the in-person meeting requirement for open meetings law is in effect until February 26, 2021. So at this point, we don't know whether the next board meeting will be in person or via teleconference. But as I said before, if you're going to play the lottery, you can probably bet on that one, that it will be extended. So board members, will you please, we will update you as soon as we know the format of our next meeting, and we will also send that information out to the Loft Board listserv and post that information on the Loft Board's website. Thank you again. Loft Loft board members, please remember to sign and email your attendance sheet. Thank you and have a safe evening. Bye now.
Thank you, everyone. Have a good night.
So long.
Bye.
Thank you all.
Thanks, Chuck.
Hmm.
Doesn't want to let us go.
I know, I can't leave.
The revenge or go to meeting.
Okay.